Legal and Privacy Brief for August 28, 2026. HireVue settles Illinois BIPA, the Biometric Information Privacy Act, lawsuit for $3.75 million over biometric data collection from job applicants. TikTok agrees to $400 million penalty for illegally collecting children's data under age 13. The Trump administration bans foreign-made power infrastructure equipment over cyber backdoor concerns, while ICE expands administrative subpoenas targeting tech companies for user data in immigration enforcement investigations. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief August 28, 2026. Next section, Enforcement Actions. HireVue Illinois BIPA, the Biometric Information Privacy Act. Class action settlement. HireVue agreed to pay $3.75 million to settle claims that it violated Illinois Biometric Information Privacy Act, BIPA, by collecting and storing biometric data from job applicants during video interviews without proper consent. The settlement resolves claims that the company's AI-powered video interview platform analyzed facial features, eye movements, and other biometric identifiers from candidates without meeting BIPA's strict notice and consent requirements. Compliance action. Employers using AI-powered hiring tools that analyze facial features, voice patterns, or other biometric data must ensure vendors comply with BIPA requirements in Illinois. Written notice, written consent, published retention schedules, and data destruction policies. Review vendor contracts and data processing agreements for BIPA compliance provisions. Source: top class actions. TikTok $400 settlement over children's data privacy. TikTok agreed to pay $400 million to resolve a U.S. Department of Justice lawsuit alleging the social media platform illegally collected personal information from children under 13 in violation of the Children's Online Privacy Protection Act, COPPA. The enforcement action addresses TikTok's failure to obtain verifiable parental consent before collecting, using, or disclosing personal information from children, despite knowing a significant portion of its user base was under the age threshold. Compliance action. Platforms with user-generated content must implement age verification mechanisms and obtain verifiable parental consent before collecting data from users under 13. Review data collection practices, implement age-gating technologies, and establish parental consent workflows that meet COPPA requirements. Source: top class actions. Next section, Regulatory Guidance. White House bans foreign-made power infrastructure over cyber threats. The Trump administration issued an executive order banning the acquisition of foreign-made technology used to manage electricity and power generation, citing vulnerabilities that foreign actors could exploit through digital backdoors. The order covers bulk power systems rated at 69,000 volts or higher, including substations, control rooms, power generating stations, and associated software that could be remotely accessed by foreign governments. The Defense, Commerce, and Energy departments must create pre-qualified equipment and vendor lists within 120 days, check transactions involving bulk power equipment, and develop rules identifying countries warranting scrutiny. Compliance action. Energy sector organizations must inventory currently deployed bulk power system equipment, identify foreign-made components considered at risk, and submit replacement plans to federal agencies. Procurement teams should await the pre-qualified vendor list before purchasing new bulk power infrastructure. Deadline: 120 days from order issuance for agency rules. Source: The Record. Next section, Privacy Developments. ICE administrative subpoenas target tech companies for user data immigration and customs enforcement, has sent hundreds of administrative subpoenas to technology companies requesting basic subscriber data as part of investigations into individuals who documented ICE activities, social media users who criticized the government, and international students who attended protests. From 2018 to 2020, ICE sent nearly 500 administrative subpoenas to Meta, Google, and Twitter. In the second half of 2025 alone, DHS sent 21 administrative subpoenas to Reddit. Multiple subpoenas have been withdrawn after users challenged them in court or companies pushed back, with courts finding the subpoenas exceeded statutory authority and violated First Amendment rights. Compliance action. Tech companies receiving DHS or ICE administrative subpoenas should evaluate whether requests exceed statutory authority under 19 U.S.C. 1509 or implicate users' First Amendment rights. Implement user notification procedures for government data requests and document subpoena challenges. Users served with subpoenas should consult counsel regarding constitutional challenges. Source: EFF Deep Links. Manchester Airports Group data breach affects 8.7 million customers. Manchester Airports Group disclosed that an unauthorized third party accessed customer data belonging to approximately 8.7 million customers associated with car park, lounge, fast track bookings, and an airport Wi-Fi sign-ups at Manchester, London Stansted, and East Midlands airports. Compromised information includes email addresses, phone numbers, vehicle registrations, and postcodes. The company detected the intrusion on Tuesday, with evidence suggesting attackers first accessed customer data a few days prior. No payment card or banking information was exposed as the affected system does not store financial data. Compliance action. Organizations in the travel and hospitality sector should conduct breach notification assessments if they process EU or UK customer data. As GDPR, the General Data Protection Regulation, notification deadlines are 72 hours from breach discovery. Implement monitoring for phishing campaigns targeting exposed email addresses. Review third-party service provider access controls and authentication mechanisms for customer data systems. Source: The Record. Next section, Litigation Updates. Finland Appeals Court revives Eagle S cable damage prosecution. A Finnish appeals court revived the prosecution of 3 senior officers from the Eagle S, a Russia-linked oil tanker that severed multiple subsea cables in the Baltic Sea on Christmas Day 2024. The Helsinki Court of Appeal ruled that Finland has jurisdiction despite the officer's argument that the case could only be heard by courts in the ship's flag state, Cook Islands, or crew members' home countries, Georgia and India. The court held that the alleged crimes were committed in Finland because damage to the country's power and telecommunications infrastructure occurred there, and that events did not constitute a maritime accident under the UN Convention on the Law of the Sea. After the crew falsely told Finnish authorities both anchors were secured, then continued dragging an anchor for 90 kilometers, severing 4 additional cables. Source: The Record. Federal judge lifts final block on Trump mail-in voting order. U.S. District Judge Indira Talwani vacated her nationwide injunction blocking enforcement of President Trump's executive order on mail-in voting, citing the Supreme Court's Monday decision that it was premature for courts to consider challenges to the order. The ruling clears the way for USPS to enforce a new rule requiring states to provide lists of male voters and use federally reviewed ballot envelopes with unique barcodes. A fresh wave of litigation followed, with 23 states, Washington, D.C., and Pennsylvania Governor Josh Shapiro filing a new lawsuit contending USPS lacks authority to impose the rule and that it violates the Voting Rights Act and intrudes on states' constitutional power to administer elections. Source: Skadu blog. Fed Governor Lisa Cook responds to removal consideration. Federal Reserve Governor Lisa Cook's attorney Ab Lowell responded to the White House's August 5 letter stating President Trump was considering her removal based on mortgage fraud allegations. Lowell stated that allegations Cook committed fraud by signing mortgage agreements for both a Michigan home and Atlanta condominium as primary residences were unfounded and untrue, characterizing the Atlanta mortgage designation as entirely inadvertent oversight without intent to defraud. The response included an expert opinion from Suffolk University law professor Kathleen Engel, concluding that no banking professional can reliably determine Cook received more favorable terms or acted with intent to deceive. The White House letter came after FHFA head William Pult sent criminal referrals to DOJ, the Department of Justice, and approximately 2 months after the Supreme Court ruled 5-4 that Cook was entitled to notice and opportunity to respond before termination. Source: Skadu blog. Australia charges 2 Team PCP members for supply chain attacks. Australian Federal Police charged Perth residents Reuben Ian Thompson, 21, and Louis Michael Giebler, 23, with a combined 14 offenses related to their alleged membership in Team PCP, a cybercrime group responsible for major supply chain attacks since March 2025. Authorities allege both were principal participants in attacks targeting developer tools including TanStack, Trivy, and Light LLM, with downstream victims including the European Commission and GitHub. Investigators estimate the campaign compromised over 1,000 organizations worldwide, exposed more than 500,000 credentials, stole at least 300 gigabytes of data, and caused hundreds of millions of dollars in remediation costs. Thompson faces 8 charges including unauthorized data modification and dealing with proceeds of crime over $100,000. If convicted on all counts, Thompson faces up to 56 years and Giebler 26 years, though sentences are typically served concurrently. Source: The Record. Next section, Policy Changes. Oracle shifts Section 230 strategy after TikTok investment. Oracle, which spent years funding anti-Section 230 advocacy groups primarily to target Google, now holds a 15% stake in TikTok and faces exposure to Section 230 litigation, affecting both its cloud services business and TikTok investment. Oracle's top lobbying executive Ken Gluck, who architected the company's dark money campaign against Section 230, now sits on TikTok's board. The company's recent political activity reports show it no longer funds the Internet Accountability Project and Free and Fair Markets Initiative, two prominent anti-tech groups that stopped updating their websites in 2024 and 2023, respectively. Oracle continues funding only the Copyright Alliance, whose remit extends beyond attacking tech companies. TikTok already faces Section 230 challenges, including the Anderson v. TikTok ruling that bizarrely concluded TikTok didn't qualify for Section 230 protections. Source: TechDirt. Next section: Compliance Takeaways. BIPA compliance for AI hiring tools. Employers using AI-powered video interviewing platforms in Illinois must verify vendors comply with BIPA written notice, written consent, retention schedule, and data destruction requirements. HireVue's $3.75 million settlement demonstrates enforcement risk. COPPA age verification required. Platforms with user-generated content must implement robust age verification and obtain verifiable parental consent before collecting data from users under 13, following TikTok's $400 million DOJ settlement. Energy sector equipment inventory deadline. Organizations in the power generation sector have 120 days to inventory foreign-made bulk power system equipment and submit replacement plans to federal agencies per the White House executive order. Breach notification for travel sector. The Manchester Airport's breach, affecting 8.7 million customers, demonstrates the scale of exposure in travel and hospitality. GDPR-covered entities must notify within 72 hours of breach discovery. Challenge ICE administrative subpoenas. Tech companies and users should evaluate whether DHS/ICE administrative subpoenas exceed statutory authority or violate First Amendment rights, following successful challenges documented by EFF and Just Futures Law. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.